Virginia Freedom of Advisory Council, a legislative agency created in July 2000. Since its inception, the FOIA Council has rendered more than 18,500 informal opinions and more than 500 written opinions on the application and interpretation of the Freedom of Information Act. Maria is also a senior attorney with the Division of Legislative Services and serves as counsel to the House Committee on General Laws. Very impressive, by the way. We should be really honored. She earned a BS degree from Virginia Tech and a JD degree from George Mason University School of Law. Everyone, please welcome Maria. She made a trip for us.
Good morning, and thanks for having me.
Good morning.
I'm a Greek person, so I already told Mark, I'm not good at standing alone, standing still, and nor can I not talk without my hands. So we're gonna I'll try to stand as closely, but I don't need a podium. I just feel that just sets a barrier. I'm really especially happy because not enough citizens take the time to learn about the Freedom of Information Act, and it's not really taught in school. I mean, I went to law school and I never had anything about the Freedom of Information Act. While it's an important law, and it really is the basic relationship between citizens and its government. Before government does, what I'm hired to do, or what government officials are hired or elected to do, this is really sort of the underpinning of how we work in a democratic republic. I always liken it to, it's kind of like FOIA, Freedom of Information, is a semi-permeable membrane. Things come into the government and things go out from the government, but it's semi-permeable, so lots of things do not go out because there's some protection, and we'll talk about that. But we brought lots of handouts. As a government agency, I like to tell people I'm here to help, and I hope that if you cannot hear me, please let me know, because I have no trouble powering up this voice. My father would always say, that squeaky little voice, anybody can hear that from miles around. Thanks, Dad. But also what I'd like to ask everybody is that feel free to ask any questions as it occurs to you about the Freedom of Information. Secure in the knowledge there is no such thing as a stupid FOIA question. As Jennifer said, Alan and I are the two attorneys that staff the FOIA Council. We answer 1,800 emails and phone calls a year. We have yet to hang up the phone and go, oh my word, what an idiot. So I'm either throwing the gauntlet down to you to be the first people to come up with the stupid FOIA question. I throw the gauntlet down to everybody. I was at DEQ in Virginia Beach on Thursday. Nobody has come up, rung the bell for the stupid FOIA question, because I don't think there can be one. So today is about what this law really says and what rights it accords you. The constituency that is the Freedom of Information Act really involves three parties: citizens, media, and the government. And all three of that constituency, we all have perceptions of what we think freedom of information means. And my experience in the last 15 years as the FOIA person for the state is that nobody is right. It's still based on perception. So the FOIA Council was established to do three things: to provide training to anybody who asks. And to me, that's our most important mission that we have. Talking to people, setting them straight about, no, this is what FOIA gives you. This is what FOIA does not give you. We also produce educational materials, and you have plenty of that there. And we, as Jennifer said, we render opinions. We do it in written form, or you can be one of the lucky 1,800 people that call us every year. And that's no problem. I mean, that's our job, is to help this democratic republic work a little bit better. So, with that, I want to take sort of the view from 30,000 feet, if you will. I think everybody in this room, more than most, understands the inherent value of open government, of transparency. And most people don't appreciate that. And it's not because they're stupid or they don't care. It's just they don't know FOIA. They don't understand sort of the basic building blocks that this law is. So transparency and open government, sort of abstract kind of terms. They seem sort of up here, but they're not really. They're very practical ideas about whether, something's going on with city council, or I'm from Richmond, so I don't get Channel 13, so I don't know what happened last night, so if you want to tell me, that's fine. But the idea here is that it becomes important to all of us when it impacts us as citizens, even the government folks in here, and I'm glad there are some elected officials here. That is wonderful. Because under, again, this constituency that there is, only government can violate the law. Citizens cannot violate FOIA. The media cannot violate FOIA. So today, like I said, we'll talk about what are the rights that FOIA gives you. But back to open government, so part of what we teach people, and the majority of who we've taught, I've just told somebody that we've been tracking the audiences that we reach. And since March, we have talked to 1,639 people about the Freedom of Information Act. And most of them are government, but they need to know it because the law puts all obligation on the government. So you all don't really need the explanation of why it's important as much as other people to get that moment of, because we in government are always on the receiving end of a request. And that's just the way it goes. That's the territory we find ourselves. But at the same time, just using myself as an example, I was hired, my job is to write the law, general laws. I mean, you think, oh, what kind of committee is that? We do all ABC, all gambling, public procurement. So it's not a bad committee, but my job is to write the law and to advise legislators and to do all the FOIA council things. So my main job doesn't really involve responding to FOIA requests, though that comes with the territory. That might be in the other duties as assigned category. But that's an obligation I have. And yes, the FOIA Council does get FOIA requests. And FOIA in Virginia, and that's the law that applies to us, there's a federal law, it applies to federal agencies, has two sides. It has the open records side, which applies to anybody in government, elected, appointed, employed. That basically, public records belong to the public and for the most part should be available for the asking. We're still in an asking kind of world, though in the information age, the idea that you have to go ask the government for something here we don't have a problem. But most people who have grown up and never knew there wasn't an internet, the idea that you have to ask somebody instead of just searching it online is a foreign concept to them. But, the example is, should you have the right to find out if there's a landfill going in, or they're converting your favorite park to a gated community, a condo? You have the right to ask for records. And so we're going to talk about, the record side and the meeting side applies to members of the school board, members of the city council, boards of supervisors, committees of the General Assembly, and for those elected officials, okay, I work for the General Assembly. People have to have a job, so don't throw anything at me, because I work for the General Assembly, because they tend to be the do as we say, not as we do group, and I get that, So the meeting side just applies to deliberative bodies, and we're not going to spend much time with that. To the extent you have questions, fine. But the record side, so we need to understand what the heck is a public record in the first place. And a public record, we define it as a public record. It's anything that's owned by the government, prepared by the government, or merely in the possession of government as it relates to the transaction of that entity's public business. Okay? A lot of people confuse the FOIA Council as we are the central repository of all records at all levels of government. Yeah, no, not so much. We're the custodian of our own records, but we're the FOIA Council, so most of our stuff is like out there. So public record, we don't care if it's a database, we don't care if it's a piece of paper, it can be a map, it could be a photograph, it can be with law enforcement, they have dashboard cameras. On buses, there are video cameras on buses that are recording public record all the time. So regardless of physical form or characteristic, if we own it in the government, we've prepared it, or that merely is in our possession. How many people in here have a library card? Okay. The public library system, before you had a library card, didn't know anything about you. They didn't know your name, your address, all that other stuff. When you filled out the form to get a library card, you created a public record. And you voluntarily provided, so the way I think of public records is, on the government side, we have a line from us to infinity. And anytime anything crosses over that line that relates to our public business, it becomes a public record. So, in this case, in possession, we all filled out some sort of form to get a library card. We voluntarily knew it was coming over to the government side. But is that a public record? Yes, because we're in possession, it relates to the library's business. But the disconnect is most citizens think that they can interact with their government in a confidential way. No, that's what open government is for. It's that semi-permeable membrane. All of a sudden, if somebody were to make a FOIA request that says, we want the name and address of every citizen who has a library card in the Portsmouth City Public Library System, how would you feel about that? Would you feel like, hey, wait a minute? But at the same time, you have interfaced with government. And so your name and address, if somebody requested it, they get it. They get records that show your name and address. Now, in the library situation, so you see the disconnect, because as citizens, on the one hand, we think, no, every time we interact with government, it should be confidential. Well, how do you square that with a transparency, open government concept when you voluntarily provide things to the government? So that's that semi-permeable membrane, is things come in, and we put no value on information except good value. We don't distinguish, well, this is a good reason, that's a bad reason. Records are records are records. Information is information is information. Now, FOIA does say that you don't have to release, if somebody made a FOIA request for everybody in here that had a public library card, for the names and addresses, that would have to be released under FOIA. And citizens find that like, whoa. But if they wanted to find out what you're checking out, or what you're using at the library, they would not be able to get that, because we're not going to connect you with your right to look at whatever you want. It's a public library. So my point in bringing this up is twofold. One, this idea that citizens do not have the ability to interact with their government in a confidential way. That's a crazy notion, though we have it in our head, that somehow our privacy should be protected. There is no law that says there shall be privacy. So when you interact with government, you fill in a form, you sign up for a park and recs program, a pottery class, whatever, you are voluntarily giving the government public record, which this law is about mandatory disclosure. Mandatory disclosure means they must give it to you if it's requested. But FOIA balances two competing interests. The right of access, the ability to get records from government or to attend public meetings of deliberative bodies, against the need of government to function. Okay? FOIA recognizes that part of government can play it close to the vest, and it's always in the public interest, since we are all the beneficiaries of everything the government does. But consider the idea of your public library cards. What we're going to protect is your name connected to material that you may be checking out. That we can play it close to the vest. So FOIA allows, in this balance between the need of government versus access, there are times when government would say no. We don't have, but they can never just say no. They have a procedural requirement to respond in a certain period of time and to provide most responses other than, sure, here it is, in writing, whether it's an email or a letter. So that's the basic process. But in FOIA land where I live, the right question is not whether it's a public record, because if we in government have it, it belongs to the public for the asking. But the right question is not whether it's a public record. The right question is, does that public record have to be released? FOIA as a statute is 65 pages. 50 of those pages are exemptions, that things don't have to be released. Yes, sir, did you have a question?
What about that card?
What is this? Concealed carry? Okay. The question here is, he's got a concealed carry permit. You ever wonder what that means? That they make application? It used to be, under the law, that when you made an application to the circuit court to get a concealed carry permit, everything was open so that you accept your social security number. So people could see who's got concealed carry permits, because it's not obvious. Now at first you may go, well, wait a minute, that's crazy. But the idea, it's no longer the case. The idea was, if you run a business and you hire a driver, do you think it's important to know whether the people you're hiring to perform your duties as a business have a concealed carry permit while they're out making deliveries on your behalf? Yes, you'd want to know that. Who's packing heat on the job? Because it's not necessarily related to the job. But move forward to the present. Basically now, concealed carry permits are exempt from public disclosure. So you have no right to know who has a concealed carry permit. There's two ways to look at that. One way is, wait a minute, we require them to get a permit in the first place, to get one. But to the rest of us in the citizenry, we don't get, so we're exercising a valid police power, right? You have to get a permit, just like me, a law degree or a law license. I have to take a test. I have to be licensed. But at the same time, you can't know who I am as a licensed attorney. You can't know who people who carry concealed carry permits are. When it's a license, it's a regulated kind of idea. So on the one hand, there's that. But on the other hand, with concealed carry permits, the General Assembly has made a decision that they are not open to the public. So whether in your business or you're hiring a babysitter, you're never going to know if they're packing heat, because the law has said that's not open to you. Yes, sir.
Ma'am, if my library record is available to anybody who wants to know, why is it that businesses that do business with the city and sell items that are subject to sales tax can keep those records closed when sales tax revenues are used to justify public investment in certain projects? An example, the Renaissance Hotel in Portsmouth. That was a public-private partnership, yet the public and even members of city council have no access to what the actual sales tax revenues are from that project.
Okay. I can answer that question. One is FOIA applies to the government. It does not apply to private corporations. So to the extent, in the example you raised, to the extent the government has procurement records that relate to this project, you ask the government, but it's not going to ever reach in to a private company that just does public contracting. It's not, FOIA is about getting records from government. So the fact that they pay tax, and the second response to your question is, we have a tax secrecy law in Virginia, which says It is a class 2 misdemeanor for anybody in government, whoever worked for government, whoever contracted with government, to release any confidential tax information on any business, person, or citizen. Okay, so your tax returns are prohibited from being released to anybody. Your sales and use tax is a tax. The law does not allow that to be released. Because the idea here, and I always think this is kind of a funny thing, as long as we are good tax-paying citizens, that information is protected under a class 2 misdemeanor. You will go to jail in the government if you release any tax information on anybody. But stop paying taxes, then your name goes in the newspaper and how much you owe. So while you're a good, faithful citizen, we're going to protect you, and so that's the answer to your question. The sales tax of somebody in the public-private partnership, how much they're paying in sales tax, admissions tax, gross receipts tax, is prohibited under law from being released. Now, to the extent the government has that record, they can't release it. But they can release all the rest of the procurement things, because sales tax, we know, is related, it's the excise tax, it's a volume thing. So you can figure out that they're going to be paying this much on the sales tax. But the fact that they're in a contract with the government doesn't make them the government under which you get to know everything. Yes?
I've got to get this question in before I miss you.
Okay?
This was right on time. Scenario, I've got a department head that makes $30 an hour.
Right.
And she has 5 people making $15 an hour. I turn in a Freedom of Information request. She simply, oh, take care of that. The rate that she's going to charge me is $30 an hour to do the research, not 15. How does she get away with that?
She doesn't. I mean, under the law says, as far as charging, is that the government may, don't have to charge, but this is, Virginia is the pay-as-you-go state, so a lot of states don't allow any charging for FOIA requests. Virginia, that's not how we roll. Is that it's a reasonable charge for your actual cost. So you focus on the actual. So it's pretty clear to me, and I get to give opinions, you know, in my job, that if she's not doing the work, it can't be $30 an hour. It's an administrative act. I always ask in a government context, who has a top secret security clearance? And not many people raise their hand. I say, who puts their garbage in a burn bag? And most people are like, what's a burn bag? I work for the State Department. The government doesn't recycle, the federal government, it goes into a burn bag, and then it's incinerated. So the idea here is, they're not our records. We are merely the custodian. But it's tied to actual costs, to the search. So it has to be, it's an administrative act. This is not rocket science. This is going to look for records and producing them. That's what FOIA is about. Being responsive, that we have to respond in a certain period of time, 5 working days, and our response has to take a certain form. So if she's not actually searching for the records, she may not legally charge $30 an hour. It's the person who's doing the work. And there's no fringe benefit calculation that's included.
So the second part of that
Yeah.
question is, may I request him to provide proof of who did the research? Is that included in the FOIA request, or is that part of the cost?
FOIA is about getting records from government. To the extent they have a record that shows who did the work, you're entitled to it. But part of the request is that I want proof that you're doing your job right, or you're doing. And I have to tell you, I'm a dedicated public employee, and I take great offense when people call me and say to me, straight out of the gate, I pay your salary, I'm expecting you to do this, and treating me like give me one chance to mess up before you cop the attitude. I mean, you know, that old adage, you get more with sugar than you do with honey. I mean, if government has treated you badly, fine, cop the attitude. But when you come in, we're all just human. And when you come in, and I've had people do it and had reports of it, and I'm not blaming you, but you can just be mad at government. And people use FOIA requests as a way to slam government. They're not interested in the record, it's just we want to retaliate in some way. So when somebody, and I'm just being as frank as I can be, somebody comes to me and says, Maria, I pay your salary, I want these records. What do you think my reaction is? I already told you what my reaction is. Does it make me go, oh, no problem, I'm happy. As a human being, do you think? My first impression is this. So why, as a requester, don't set that up? Unless you've had a bad experience, then I think they deserve it. But coming out of the gate, it doesn't. If the goal here is to get records from government, and that's what FOIA is about, then there is a brochure, a little blue one, that talks about, I did it on Veterans Day, so it's got like, it's supposed to have camouflage, it's called FOIA Boot Camp, about how to really think about your request. So this goes to the question of, what does FOIA really accord you as a citizen? FOIA says, ready access to the records in the possession of government. That's the guarantee, is that if they have that, you have the ability to ask for it. But like I said, there are 175 exemptions that say, government, you don't have to release these records. Now, things we all can agree with, when the cops are doing criminal investigations, right? We all want law enforcement to get the bad guy. So their criminal investigative files do not have to be released to the public. And we get that, right? Why should, because if they release them, then the bad guy is getting away. So there are certain positions the government may take under FOIA. So privacy, scholastic records, medical records, personnel records of people in government. You read about the ABC agent, right? Lately in the paper where, the unfortunate student, the agent threw him down to the ground, 10 stitches in their head. They did an investigation, and the request was, we want a copy of your investigation. Well, technically, it's a personnel record. I mean, there's some level of any business organization, any organization, personnel is protected because we internally manage it, you don't externally manage it. But the idea here was, okay, this bad, we all saw it, we want records to see what you found. But essentially, that was a personnel record that did not have to be released, but they could have released it. So FOIA is about getting records from government, whatever they may be. Whether body-worn camera, video, we don't, again, owned by us, prepared by us, in the transaction of the public business of the entity. So FOIA, let's talk about what it is not. FOIA is not a law that allows you to ask questions and get answers. That is not FOIA. FOIA is about getting records from government. So to the extent you call and say, explain to me why you did this. Why did you all do that? That's not a FOIA request. There is no law that governs that. But as people in government tend to be interested in the public good. We're not making $1 million, right? And I'm not, and do not misinterpret anything I say as woe is me in the government, okay? I have a case in point. I drafted legislation. Years ago, there was that riverboat gambling bill for the Tidewater area. I had spent, I can't tell you how many hours to draft that from whole cloth. Of course, it got defeated. The next year, all the lobbyists took the draft that I had already made, and they got paid $100,000 per draft. And I'm like, whoa, I'm in the wrong business here. I did this all for, and again, I'm not, woe is me. But the idea here is people in government, my experience, okay, your experience may be different, have sort of a public service bent. Because I look at it as, why would you voluntarily, whether you're elected or not, go to a place where you're not really making market rate, people think you're a bum, that you're sitting around doing nothing, waiting to see how you can mess around with them. So people have a public service bent, I think. My experience in government has been that people make mistakes out of ignorance. Sure, we can all point to bad apples that don't do the right thing, and the law protects that. It allows you to file a suit. Now, whether that's a successful or a good option under the law, that in your case where they're overcharging you, you get to file suit against them. You don't have to have a lawyer. All you have to do, we have a FOIA petition. My rights were violated because you charged me $30 an hour when somebody else did the work. The burden of proof is on the government to show we complied. So if she said, how is she going to prove I did the work? Then you're entitled to recover your attorney's fees and costs. But telling citizens, anybody, your only enforcement mechanism is you have to go to court. It's not the greatest one out there, but this is America. It's your rights that are violated, and I tell the newspapers the same thing. It's not the most ideal situation, but if government is violating this law, you have a remedy. And if you elect not to take that remedy, then you're kind of going, it's okay. Because nothing will correct a public official or employee that's having a lawsuit filed against them. To be against the body. So that's why the FOIA Council was created. So that you could call us. We're not the FOIA police, but we'll call. I'm happy to call her and go, the law says actual cost. If you're not doing the work, it's not $30 an hour, and you're looking at a lawsuit potentially, which you will lose. Okay? So in this world of FOIA, so it's not about getting explanations. It's not about, it's about getting records. Now the trouble with getting records is we don't know what they have. We have ideas about what government may have, depending on what level of government. And I use this as an example in a government setting. I mean, everybody I talk to, like at DEQ, the regional office in Virginia Beach, they all do different things at DEQ. And I said, okay, now you know what I do. Can anybody tell me what records I have? Or can you say across the aisles to you other people that all work for DEQ what records you have at DEQ? And everybody was like, well, no, not really. And I said, precisely. Imagine the poor citizen. We're all insiders, and we don't know. So imagine being a citizen. We call things certain words. In the law enforcement, it's a CAD this, and it's got an RM, everything has a number. Well, the citizen doesn't have to know that. So be careful in government of controlling on what the words they use. Because if they use something like information, you're like, oh, it's about records. Don't go there. So part of that blue handout is how to formulate a FOIA request. We have a toll-free number. Call us. We'll help you. Because FOIA requests do not have to be in writing. You don't have to put them in writing. Somebody lays a form to you and says, you have to fill out our form. No, you don't. But you don't have to. They can always ask. And I think it's always a better idea because if the point is to get the record, then to be as clear as possible. And have a discussion. I mean, if you ever look on our website, all our written opinions are out. Communication is key. We're just human beings to human beings. So do some research first to educate yourself. Look online. And maybe you feel like, well, I shouldn't have to do that. Well, but if my position is always ask the question conducive to the answer you want. So if you speak the language a little bit better, then you can identify, because the only obligation under this law on you is to be reasonably specific in identifying the records. Well, what the heck does that mean? We wrote an opinion about it. Government needs to know enough, get something enough from you to know what to look for, or to ask questions. Do you want this or do you want that? But we all too frequently have perceptions of what the government should have. And we may not have it just the way you want it. You want 6 data elements out of something. We want to see X, Y, Z. Well, we may have hundreds of pages that reveal that. It's not all neatly in one record. So government can never ask you, why do you want it? What are you going to do with it? Because motive is immaterial. This is a right to know law. But at the same time, if your goal is to really receive records, then have a little bit of a discussion, because there's no law that says how records have to be kept. So if you're going to, like, the building official, and you want to know every violation against this particular address, they may not keep it by address. It may be a chronological listing of violations. Then you have to identify that particular address. So that's where the charges get a little more, because now you're trying to, you've got all, if they're kept this way by chronology, then you're looking for a particular address, well then it's going to take you some time, and FOIA allows that charge to be made. Yes, sir?
Could you talk a little bit about what constitutes a FOIA-able record as opposed to something that you cannot FOIA?
Well, my position is you can ask for any of it, because the obligation is on the government to identify what's exempt, because they can't say no unless there's a law, state or federal law, that allows them to withhold it. So mandatory disclosure means everything is available for the asking unless the law has created an exemption. So, like I said, there's 175 exemptions, so it's a little hard for me to chronicle those, but they tend to be, but minutes of the city council, there's no exemption for that. Salary information, position description, names of public employees, there's no exemption for that. You go into a public building and you see plastic containers on the wall that hold a bunch of documents so you can self-help or stuff online. Those are all public records that they're actually making available to you. And I'm not here really to say, rah, rah, the government, we're all great and we never make mistakes. Not coming out of my mouth, okay? But I'm saying it's all about approach. And so that's how it lays out. So I can't be any more specific to your question, is that you ask for it. Go ahead and make the request, because the burden is on the government, because this is part of the procedure of FOIA. Upon receipt of a FOIA request, I liken it to a baseball analogy. You're reasonably specific, or you help them understand what it is you're looking for. All those responsive records are on deck, and to the extent state or federal law allows you to take some portion of that off, or like in a criminal investigation, all of it, they may withhold it from you. But they have to cite their authority in the law to do that. Otherwise, it goes to the field of play. So they have to cite the exemption in the law that allows them to withhold the record you're seeking. So I can't be any more specific, because we don't have enough time to go through 175 exemptions in FOIA alone. Yes, ma'am.
Hi, I'm Donna Sy, and I live in Woodbine Farms. But what I want to know is the EDA has closed sessions about, say, property that they're negotiating on,
Okay.
right? So they have closed session, and you can't get any information on what they're doing
Right.
to negotiate. Well, then, after that happens, then they say, well, so-and-so is buying the property. It's like they've made the decision already without any citizen involvement in saying yay or nay, that they don't think that's a good idea. So the point I'm saying is they make these ideas, come to these conclusions or decisions in a closed session, and then when they come out, they've already made a decision, and we, the people, don't even have any opportunity to give our feedback on it.
Okay. So this is a meetings question, and basically closed sessions are like those record exemptions. There are discussions that don't have to happen in the public realm, because again, we're protecting a public position. The example you give is they're buying or selling real estate. Let me make it personal. Next door to my house, there's 1.5 acres of woods. let's just pretend I own it. I aspire to own it right after I win the lottery, but I want to own that. If I knew Henrico County, where I lived, was looking to buy that real estate, how many people think the price just went up? You see, and that's what closed session is, that you're protecting the bargaining position. But you're not allowed to make final determinations in a closed session. You can have a straw poll in a closed session, because how do you know you're finished with the discussion unless you kind of get a sense that everybody's like, so we're going to move forward on this? But FOIA, again, as a procedural law, in that context, you have to come out of closed session and make a motion that the language of the statute is substantially identifies the subject, what you're going to do. So if there is no vote in an open session to buy this piece of real estate by the EDA, then that's a violation of the law. Because FOIA says failure to follow any procedure is a violation, is deemed a violation, and the government has the burden of proof. And if you file a FOIA petition, it's not months down the road, sometime later. 7 days after filing, that agency or body is in court and have to prove. So if the EDA is not making an open motion to put into effect something, it says anything agreed to, any contract proposal must be made by open motion that has the substance reasonably identified. So if they're not coming out and making that public motion, then FOIA goes one step further. It hasn't happened yet. It's not effective. So again, I know sitting here saying, well, you get to sue them, is not like, oh, it's not an expensive proposition, but it's something, why can't the government just do what it's supposed to do straight out of the gate, is really the better question. And that's what they need to do. And that's why you have the FOIA council. So I can't go and make anybody do anything, but I will certainly call them. So that's the idea of a closed session, but there's procedural requirements of how you close the session and what you can talk about in that closed meeting. But in terms of public involvement in that decision, there's ways to interact with your government besides showing up at an open meeting. If you want records about what's going on with the EDA and purchasing of real estate now, again, because it's under negotiation, they wouldn't have to give those to you, because it damages the public position. But those kinds of decisions, at some level, public employees and public officials are entrusted. I mean, it could be you, are entrusted and know that there's a state law that governs their activity. And do people make mistakes, or do people purposely, and FOIA goes a step further, if it's a willful knowing violation, we knew we were supposed to have this motion, but we just didn't want to do it because it's a politically hot topic, then they violated the law, and there's monetary penalties that can be assessed against them. But that's sort of the give and take of that balance, is that government is supposed to be protecting the public position at all times, whether that's in contract work, negotiating a deal for whatever, criminal investigations, personnel records. But again, the procedure that ensures you the right is they have to, any exemption from openness, they have to cite their authority to do it. Okay? Anybody else have a question about that? Yeah, Jennifer.
So, which is interesting, because I didn't know FOIA actually governed that closed meeting. So, does FOIA also rule on the fact, let's say there's a closed meeting, and it's a discussion, I get it, there's a contract involved, but a settlement evolved within that closed meeting among the members that would come out into the public, but there's a delay in coming into the public. Does FOIA govern the time that they made a decision and presented it to the public?
Yes, FOIA does. The question is, okay, they have reached some sort of consensus in a closed meeting that was lawfully held. So is there a delay? I mean, how soon do they have to come out to put it into action? Well, if they know what if they're gonna move forward to put something into effect, it's immediately when they finish the closed session. But consider the situation, they're in a closed session negotiating purchase of real estate. They haven't reached an agreement at that point. They sort of take a consensus, how's everybody feeling about this, should we move forward? And it's like, no, so they don't have a decision. Now, FOIA doesn't say they have to come out in open session and go, we haven't decided yet. But that would be helpful for us, because it's the rest of the story. They've kicked us out of a room, and we have to trust, because the meetings law is all about integrity in government. We have to trust that they're gonna stay on topic, and FOIA requires that. That's why they certify after a closed session. We thought it was a lawful exemption, and we stayed on the topic of purchasing property for the EDA. But if they haven't come to a consensus at that point, then there's no motion to be made to put something into effect. So that would be the only time. If they haven't decided or don't know where they're going with some particular issue, then you're not gonna get a motion afterward. But I think so much of FOIA is public relations in its application that you come out and say, look, we haven't decided. There will be no motion because everybody's waiting to see what happened. And so if nothing's gonna happen, just tell them.
If there's an instrument that, say, city council is required to sign saying we're getting ready to go into closed session to discuss blah, 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 how detailed does that instrument have to be?
Okay, it's a motion, you know, it's parliamentary procedure. There's a motion, and FOIA dictates what that motion looks like. A statement of subject, a statement of purpose, and the code site that allows you to close that meeting. Now, a lot of newspapers report, oh, you know, the Board of Supervisors went into, or the City Council went into 37 closed meetings last year. You know, they're hiding something from us. No. The issue is, if the law allows them to go into closed session, they are authorized legally to do it. So on sheer volume, it's not a good marker of what's going on. You shouldn't read into that they're all behind the doors and doing everything illegally. So there's this funny rule of three always in there. So there is a section in FOIA, 2.23711, which says purposes for which closed meetings may be held. And it has the discussion or the disposition or acquisition of real property where discussion in open session would adversely affect the bargaining position. Okay, so that's why. But that's purpose. Most of them are like a paragraph long. And the mistake that is most commonly made is the law already gives you purpose and code site. So it's the subject that never shows up. That's the trouble. And they think by reading that whole purpose statement that somehow you have magically arrived at subject. You have not. And your minutes will document your violation. So in our handout for meetings, we have how to compose the proper subject. Because FOIA doesn't say that substantially identifies the subject, it says you just have to have a subject. And that subject is also a little negotiable, because you want to give notice to the people why you're kicking them out of the room without giving away the store. I use a school board example since the school board hires all the personnel. If the school board, where I'm from, Alexandria, says we're going into closed session to talk about the disciplining of a high school principal. That's the subject. We're disciplining a high school principal. The purpose is personnel under this section. I haven't given anything away, because in Alexandria there's like 600 million high school principals. But take it to Washington County, Virginia, Abingdon. School board says disciplining a high school principal, there's one high school principal. Now everybody knows who's under the act. So the subject can kind of move back a little bit to say the disciplining of a school board employee, because it's a privacy-based exemption. So subject is a tough one. And the FOIA Council, we're in the second year of a three-year study, and we looked at that, because I've told them, everybody misses subject. Everybody, always. And your minutes will document that violation. So it's a pretty easy thing to go to the court and go, there's no subject here, Your Honor. So we're thinking, because just regular folks, right? Doesn't subject and purpose sound a lot alike to you? Yeah, you know, and we're not any smarter in the government, you know what I mean? So they seem, and so it's like, well, maybe we're using the wrong word. You know, maybe there's another descriptor, or maybe we should say that substantially identifies. And I'll give you an example. Over on the Eastern Shore, there's in the Cape Charles, right? There was a school building, a couple of years ago. School building everybody went to, everybody they were ever related to went to. Well, the school itself has been boarded up and fallow for decades. So it's non-income producing real estate that's on those town people's backs. They have to pay for the maintenance of this building that is not being used. Taxpayer Alliance, what do you think of that? Not much, right? Why are we paying and it's just sitting out there? Why don't you all do something with it? Okay? So they have a closed meeting. And the purpose is to discuss the acquisition or disposition. So buying or selling or leasing real estate. The subject they used was to discuss an unsolicited proposal. And of course, I get the call. Maria? Okay, the purpose was real estate. We pretty much know it's the school. But all they said is to discuss an unsolicited proposal. Did they violate the law? And I try not to be a cagey attorney. I'm trying to give this is how it works. Very pragmatic. And I said, I can't say they violated the law. It's not the greatest subject I ever heard. But what had happened behind the scenes is a developer approached this town council and said, let's talk about, I have a proposal. I will turn this into low and moderate income housing if you sell it to me, and then it'll be income producing, and then you'll get to do something with this historic school. Well, they weren't sure that that was something they wanted to do, so the most on the subject was this unsolicited proposal. Because the law says a statement of subject. It's either there or it's not there. It doesn't say substantially identifies, because under that standard, unsolicited proposal doesn't substantially identify anything. But is it a statement of subject? Yeah, kind of. So you can't really say, that's when there's a song from a long time ago, a popular song, that Johnny Guitar Watson, that goes something like this. And when you look, you will discover that it's a real mother for you. Oh, it's a real mother for you. My purpose is the law can't possibly contemplate every situation. And that's when it turns into a mother. You know? Is that enough subject? So maybe we change the word that'll be more descriptive to somebody. But as that discussion moved forward, they were talking about, then they said the school, and everybody knew, and it was all proper. Then the citizen unrest came to the point is, we thought you sold it too cheap, and we're mad about that. Well, the question is, how do you get consent of 8 million people, elected officials? So you elected them to make the best decision they can. So if you don't like the decision, that's a ballot box issue, okay? Yes, sir.
Ma'am, when public bodies hire people to work for them, is the list of candidates available to the public?
No. When you're hiring it can be FOIA, because again, those are personnel records, but say a deliberative body, the school board is filling a vacancy, or city council. Or, somebody's applying to be, the head of the FOIA agency when I leave. Those are personnel records, don't have to be released. And the way FOIA works on the record side is, but you can release them if you want to. That's your discretion, because there's no law that prohibits the release of who the candidates are. But it's not required, it's not subject to mandatory disclosure. And so what is the public policy under that? Because right now it sounds, well, wait a minute, if you're gonna hire somebody or you're gonna fill a vacancy on the school board, we wanna know who's up for the running. Well, has anybody in this room ever applied for a job that your current employer wasn't aware of? You see? that's the policy behind it, is until there's some, we're not gonna tell you who the candidates, because one candidate may already work somewhere else, and if their boss finds out, they're gonna need a job then, right? So that's what the public policy behind the personnel exemption is, partially, especially for interviewing candidates. The law says you can interview candidates in closed session, but you can only talk about them. And also, you can do it when it's the executive, like the city manager. You can do it at an undisclosed location in 15 days. Because again, the press will know when you're gonna have your next meeting to talk about candidates for the city manager position. They're gonna camp out with their cameras at that location, and all of a sudden the person who's from Iowa, who's, you know, whoever has another job that their employer's not aware of. So that's the position, so that we get the best candidates. But before you, like when you're filling a vacancy, before they can fill that vacancy, they have to say, we're filling this vacancy on the school board with person X. And they'll probably run all of their qualifications. Yes, sir.
Excuse the laugh that this might, I bring in, but the city hired an auditor, and we understand that he only works for city council. Would I have the right to request the city council's direction to what he was to order?
Yeah, if the city council did a motion, or what you have the right to under FOIA is that person's name and their position description and their job classification. So that may already show you what, but if city council passed some motion that said, okay, auditor, these are your marching orders, then you have a right to see that. But they have to create the record. So if there's no record of it, then there's nothing to request. And as I tell people, in FOIA land, words never hurt you. But in the government, like we are in the world, everything is about CYA. So there's some record somewhere. It's just the record may not look like what you think it might look like in your head. That's why that discussion. You had a question?
Say I make a reasonable request, something that should be under FOIA, and I'm not asking for 10,000 pages. What's a reasonable time limit to receive something?
Okay, FOIA says upon receipt of a FOIA request, government has 5 working days to respond. Day 1 is the day after they get it. Why? Well, if they got it at 10 o'clock in the morning, that seems like you ought to get busy. But what if you get it at 4:30 in the afternoon? So it says start counting the next day, working days, so no holidays. That's a statutory requirement. This is not a guideline or a regulation. That's what FOIA is about, being responsive to the citizenry. Respond in a certain period. So within 5 working days, you have a right to inspect the record or to receive a copy of that record, your choice. But that doesn't mean on the 5th day, you have to have it in hand. It means they have to respond to you by close of business. So if they're mailing it, they have to mail it out by the 5th day. Also, it says shall promptly. So FOIA, it doesn't make a distinction whether you show up at that agency or body, or send an email, or call them on the phone and make a FOIA request. It's all a FOIA request. But just because you came to the office doesn't mean they have to drop everything and provide that record to you right then. They can say to you, no, you need to make an appointment in the next 5 working days to review these records or to get copies or whatever else. So, but one of the responses is, sure, here it is. And I tell people, all of us experience difficult people. The more difficult that person, you have some history with them, deal with them constructively. Get them, serve them, and get them gone. Because a lot of people come, and like I said, they have some axe to grind generally, and not everybody. I mean, this is a citizen's right. I'm all about that, and I'm happy that you have this organization, because there is a responsibility of citizenship. You can't just sit back and poke fingers and make comments if you don't get involved, right? That's sort of how this whole country works. But to the extent that Some people are just grinding an axe because they're mad about something else. Then you might want to serve them quickly and get them, moving them on, because that's not really what they wanted. They wanted the who struck John. And when you give it to them, they're almost mad about that because you did what the law says. Now, the law allows them to extend the time. If they say it's practically impossible to get those records or search for them in 5 days, sending this writing to you that says it's practically impossible gives them 7 additional working days, okay, the need of government to function. Because FOIA requests are for records that exist. Government doesn't have to make up anything in response to a FOIA request. It's for what we already have. Nor do we have to abstract or summarize from the records. But in a database, doing a word search is not creating a new record, and it's not summarizing. Most of government has these big honking databases, and we're extracting those data elements, and they have to do it. So if you want it in an Excel spreadsheet, you get it in an Excel. If you want it burned on a CD, you get it, but you may have to pay for the CD.
Okay, we're going over a little time, hoping for a question or two and then a wrap up. Go ahead.
I have a question about asking to get FOIA information. Can the city charge? Because that's what the city of Portsmouth wants to do now. There's $5 for the first time. If you get a lot of pages, I think it's $15 or more. This is something they just passed.
Yes, FOIA is not free, and that surprises every citizen anywhere. Oh, like, what? And it's like, we already paid for everything. And you'll see in that charges book, the first question is, how many times do the citizens have to pay for this? But it's not the citizenry generally, it's a single requester. But they can't put a flat rate out. Actual cost is what it's tied to for searching for the record, right? The time it takes somebody to go find it, accessing the record, which is going to me in a database and getting out the parts the law requires to be mandatorily disclosed. Supplying the record, if they do redactions, because the law allows some of that record to stay behind, or requires that, tax secrecy law, you can't release it. So the response is, we cannot release this under this section of the code. And for duplicating. And so in that little charges document, we have a formula to figure out for government, how much does it cost to run a piece of paper through a copier? And the question I get from citizens is, well, I can go to Kinko's. It's 5 cents at Kinko's. We're not Kinko's. We're not in the business of making copies. So it depends. Do you own the machine? Or did you get a good maintenance contract if you lease it? So there's no flat rate, but they can. But to the extent they say all FOIA requests are $5 on top of searching, no, they can't. Actual cost of going to find the records that have been requested.
They used to do it for free, and it got out of hand, I think. So many people was asking, so, I mean, people will call, but now they said they're gonna start charging.
Right, and DEQ, their policy is, for the first half an hour of searching, they're not gonna charge you. But when it goes past the half an hour, they're gonna start charging the administrative rate. And the fact that they hadn't charged in the past doesn't force them to never charge again. Because again, that balance.
Okay.
See how FOIA can go? We'd be here all day, couldn't we?
Yep.
You know?
Thank you.
And I'm happy to come back. I offer that, certainly, if you have time, another time.
Thank you.
Thank you.
Well,
Thank you very much.